to listen to this again and forward to anyone else you think might benefit from it. So good morning. Today's Tuesday, November 17th, and thank you for joining our call on the 2020 election and the impact to employer-sponsored health plans. Our presenter today is Stacy Barrow with Marathas, Barrow, Weatherhead and Lent. They are our attorney partners based out of Boston. They specialize in ERISA and employment law. We're recording this session, as I mentioned, and a copy will be posted online. Please post your questions in the chat box, and we'll try to get to all the questions at the end of this call as time permits. If we are unable to get to your question, we will follow up with an email response. At this time, I'm going to go ahead and hand the call over to Stacy Barrow. Welcome, Stacy.
Thank you, and good morning, everybody. It's Stacy Barrow here from Marathas, Barrow, Weatherhead, Lent, and we are proud to partner with Benefit Concepts to offer today's webinar. Our topic today is an update on the 2020 election and what it means for employee benefits. We'll certainly cover the election. We'll talk about the recent Supreme Court case on the Affordable Care Act, where oral arguments were heard last week. We'll look at what's next for the ACA under a probable Biden administration, the future of COVID-19 relief, and then a couple of new rules on price transparency, and we'll follow up or finish up with a couple of minutes on ACA reporting for 2020. So in terms of the election update, if you go by the Associated Press, they do seem to have called it for Joe Biden. The current electoral college count, last I checked, was 290 to 232, and that doesn't include the 16 additional electoral votes for Joe Biden. So he is the presumptive president for the next 4 years. It doesn't seem that we have the same kind of organic issues that sprouted up in 2020 with the Chads, and you had tens of thousands of people claiming that they were confused about the ballots. That just does not seem to be happening this time. In terms of the Senate races, there were a bunch of interesting races this time. Going into the election, Republicans held a fairly narrow majority, 53 seats to 47 seats, and it was an uphill battle for the Republicans. They were defending about 24 or 25 seats. The Democrats were defending, I think, about 8 or 9 seats. And some of them were pretty hotly contested, but Republicans held out. They actually flipped a seat in Alabama, and they held on to seats in Maine, Iowa, North Carolina, South Carolina, and Kansas, all of which were fairly tight races. The Democrats did flip 2 seats, one in Arizona and one in Colorado, which gives them a net gain of +1 in the Senate. So post-election, the results are 50 Republican seats and 48 Democrat seats. Both of the seats in Georgia will need to have runoff elections January 5th. So in order for Democrats to take control of the Senate, they will have to flip both of those Georgia seats, and that'll give them a tie in the Senate, and Vice President Harris will be able to cast the tie-breaking vote. From what I kind of seeing out there in the papers, it seems odds are pretty good that these seats will be split. One will go Democrat, one will go Republican, or they could both go Republican. It does seem a little bit unlikely Democrats will flip both seats, but the election is a ways off. Folks can still register for this runoff election, so I think there'll be a lot of attention on these elections. I know that they are looking at having debates again, and for one of the seats, the Republican who's running, he says he doesn't want to go back into the debates. They might have a debate without him. So I think these races will get national attention in the next couple of months. In terms of the House of Representatives, Republicans also did pretty well there. They defeated incumbents in South Carolina, Iowa, and New Mexico, and they held on to seats in Missouri, Michigan, and Ohio. So they picked up a small handful of seats. The Democrats will still maintain a majority, but it'll be their smallest in 18 years. So, what's the immediate impact here? The stock market in the day or two after the election seemed to like the election outcome. We got a small bump in the market. A few days later, there was some news released on a COVID-19 vaccine, but I think that was after the first 48 hours or so of the election. And I think the market's reaction is likely due to the likelihood of a divided Congress. Again, it kind of looks like Republicans, at least the odds are, they will hold on to the Senate, so we'll have a bifurcated Congress, and less legislative action is probably likely in a divided Congress. If Democrats had control of the House and the Senate and the presidency, you might see a lot more legislative reform. We'll talk about that in a little bit. But much of the implementation of the ACA is done by executive action. You saw that over the last 4 years, where President Trump issued executive orders and directed the agencies to write rules that his administration wanted to advance. And then when the new administration comes in, I think that it's pretty likely some, if not all, of the actions that the Trump administration took will be undone by the Biden administration. I could certainly see the rules for mini-med plans and individual coverage HRAs being altered or rescinded, as they are kind of inconsistent with the ACA. So it'd be interesting to see what the Biden administration adopts and what they jettison. But again, having that majority in the Senate might not be all that important to advancing healthcare policy, a lot of which can be done through regulation. So moving on now to California versus Texas. This is a Supreme Court case where the oral arguments were heard, I think a couple of weeks ago. And the case started off in a district court in Texas. Judge O'Connor at the district court level back in the end of 2018 ruled that the entire ACA is unconstitutional due to changes made to the individual mandate by the Tax Cuts and Jobs Act. It's kind of a tenuous decision. It was appealed to the Fifth Circuit, and the Fifth Circuit actually agreed with Judge O'Connor there in the district court and said, we agree individual mandate is unconstitutional. And then it remanded the case back to the district court to go through the law with a fine-tooth comb and figure out which parts should be saved and which parts should be severed. Kind of an outrageous exercise. But the reasoning here that the lower court and the district court gave was that back in 2012, when the Supreme Court upheld the individual mandate, they did it on the basis that it was a tax and the government has the ability to levy taxes. And the reason that we know it was a tax is because it provided at least some revenue to the federal government. And the argument is that when that individual mandate is zeroed out, well, it doesn't provide any revenue for the government, and therefore it's just an unconstitutional mandate to purchase health insurance. And the lower court and the appeals court agreed on this issue, and the case made its way back to the Supreme Court. Before that, though, the appeals court not only found that the individual mandate was unconstitutional, and they directed the lower court to figure out which pieces of the ACA should be unconstitutional, they also ordered the lower court to determine if the ACA is only unconstitutional in the plaintiff states or if really it should be unconstitutional across the country. Rather than let the district court go back and start this exercise, a number of states, we refer to them as the intervener states, and you can see them listed on the slide here, brought the case to the Supreme Court. The intervener states were basically forced to step in here because the federal government agreed with the plaintiff states that the ACA was unconstitutional, and they refused to defend it, which, it was fairly unusual at the time and actually raises constitutional issues in and of itself, where it's a violation of the take care clause not to enforce standing federal laws, but not the issue here. Move on. And so most states out there took a position one way or the other on the case. Oral arguments, again, I guess were heard a week from today, or a week ago today, November 10th. And we do expect a decision prior to the end of the court's term in June of next year. I think it'll be a lot sooner than that. I think it'll probably be February, maybe March at the latest. And of course, a decision to repeal the entire ACA would have an enormous impact and would mean a loss of coverage for at least 10 million Americans, probably 20 million. So what did the court discuss at the oral argument? There were really three main questions. One, which they spent about a third of the time on, was do the two individuals and the 18 or so state plaintiffs even have standing to challenge the individual mandate? Now, this is the way that I thought the Fifth Circuit of Appeals was going to see it, and just toss this case out due to a lack of standing. In most cases, to invoke the power of a federal court, you need to have a case or controversy where there are at least some damages. You need more damages than no damages to take a case to court. Roberts kind of made this known in his questioning. He was like, look, let me get this straight. We had an individual mandate that had a penalty, and it was legal, it was constitutional. We have removed that penalty to make the law less onerous, and somehow that makes it unconstitutional. So it's pretty clear the court does not want to, hear this case again. And I think there's at least some chance that they really do dismiss the case on procedural grounds due to lack of standing. I mean, that's the whole reason these 17, 18 states had to have two individual plaintiffs to even bring this case, because the states aren't even subject to the individual mandate. They had to find these two individuals who were willing to get up and say, yeah, we buy coverage, we buy health insurance for no other reason but to satisfy the individual mandate, even though it doesn't have a penalty. So it's an incredibly tenuous argument, and I think there's at least a passing chance that the court strikes this down due to lack of standing, because it'll be precedent, once the decision comes down. The second question was, on the merits. Does reducing the individual mandate penalty to zero somehow render it unconstitutional? And the three liberal justices are not in any danger of finding it that way. I think Roberts, having found it constitutional once, is looking for a way to save it, which brings us to the third question, which is whether the individual mandate is severable from the rest of the ACA. Kavanaugh spent some time on this, and from looking at his prior decisions, we know that he is a fan of severability. And so I think that's probably a pretty likely outcome here. They did spend some time on it. So what could the outcome be here? Here's my thoughts on what could possibly happen. The first is that they could just dismiss this case due to a lack of standing. Would make perfect sense to me. And I know a lot of legal onlookers would think that that's an appropriate decision. So they could uphold the individual mandate as continuing to be constitutional, as merely a precatory urge by the government to purchase insurance. It's no longer a command. It's not backed up by any kind of a penalty. It's along the same lines of the government telling us that we should all plant trees. There's no penalty if we don't do it. Is a law suggesting the planting of trees unconstitutional simply because there's no penalty. So that's one avenue they could go down, just uphold the ACA. They could also judicially repeal it entirely. I do think that is pretty unlikely, given the questioning. They could also repeal parts of the ACA, where they repeal the individual mandate and some of the other integral parts, like the protections for pre-ex conditions, guaranteed issue, community rating rules. These are all kind of considered instrumental to the individual mandate. Now, I don't think it's all that likely that the court will go this route either, because they spent basically no time on it. They didn't really ask too much about, what would happen if we tossed guaranteed issue, or we did away with the community rating rules. Just wasn't a big focus for them. They could also find the individual mandate to be unconstitutional and then send it back to the lower court to decide which parts are severable. That's what the Fifth Circuit did. That would be ridiculous, frankly. I can't imagine them doing that. They don't want to hear this case again. It would almost be guaranteed to come back up to the Supreme Court if they sent it back to Judge O'Connor in Texas and he went through it and picked a handful of provisions that were unconstitutional. And then perhaps the most likely outcome is they find the individual mandate unconstitutional due to the changes made by the TCJA, and they just sever it from the rest of the law, and it's business as usual. We'll see the decision probably in next 2 or 3 months. I don't think this one will take all that long to draft. And we'll just have to see what next year brings. So one thing that we have seen, I guess kind of a token effort in light of the repeal of the individual mandate, is we have seen state efforts to implement their own individual mandates at the state level. So last year was New Jersey and Washington, D.C. This year, California's, Vermont's, and Rhode Island's went into effect. We've had our own individual mandate up here in Massachusetts since 2006, and most of them generally resemble the federal individual mandate before it was repealed. So if the Biden administration doesn't reinvigorate the individual mandate, maybe we will see more states pushing for this. Is the individual mandate really all that important? That was one of the questions and one of the issues that was argued back in 2012 when it was fought so hard for the individual mandate to be upheld. Is that the argument was, well, our insurance markets will collapse. They will suffer from adverse selection if we don't have the individual mandate. And we know now that while none of us like our renewal increases from year to year, the insurance markets, the individual and small group markets, are clearly surviving without the individual mandate. The three-legged stool doesn't exactly topple over when you don't have an individual mandate. Right about the time when COVID was really beginning to kick off back in March, the ACA turned 10 years old, and about 24 million more people are covered since the ACA's inception. About half of them are covered under the marketplace plans, and the other half are through Medicaid expansion. ACA kind of continues to be pretty popular. Folks are still enrolling in the marketplaces. We have seen marketplace enrollment decrease slightly over the years, which is expected because you have more states that are expanding Medicaid. as more states expand Medicaid, it pulls in the lower earners, or it pulls them out of the exchanges and into the Medicaid system. So the more states that expand Medicaid, we do expect to see a little bit of a drop off in the marketplaces. So what do we think is going to happen, or what do I think is going to happen under a Biden administration? Well, certainly if they manage to take control of the Senate, I think we'll see some legislation to build on the ACA and try to lower costs and prescription drug prices for for individuals. So legislatively, we could see some amendments to the ACA to expand the subsidies to cover more middle class families, make the top end of the range a little bit higher, and then also ensure that employees and families that don't have affordable family coverage through their employer can still qualify for the premium tax credits. As you know, currently the eligibility for a premium tax credit is keyed solely to the cost of single coverage. And while a lot of employers charge up significantly for family coverage, and so employees get precluded from obtaining a premium tax credit based on the cost of single coverage, even though family coverage really isn't affordable. And so this was an intentional design of the ACA, but perhaps we'll see that adjusted somewhat in the future. Again, if they can do it legislatively, I think they'd refund the Medicaid expansion program and try to encourage the dozen or so states that haven't expanded Medicaid yet to reconsider. And I think we'll also see directing of funds at the federal and state levels to increase the enrollment in the marketplaces, get the navigators funded again. That was something the Trump administration did. They pulled, I think, 90% of the funding for the marketplace navigators. So I think that'll probably be reinstituted. So, and we've talked about this before as well, single payer is really not the answer here. It's not really the Biden approach either. Anytime the states have tried to go single payer route, they've had to abandon those efforts due to cost constraints. We've seen that over the years in California, Colorado, and Vermont. Even California, with their massive economy, could not make single payer work. That it would have cost about 2 times their state budget. The Biden healthcare approach, at least what we know from Joe during the debates, what he's said before, he is not a Medicare for all supporter, not a Green New Deal supporter. He's not the world's most progressive candidate. He said that he would expand on the ACA. He has mentioned building a public option alongside of the marketplace. This would really be for people who cannot get affordable employer-sponsored coverage. And despite this being a public option, it could certainly end up taking more of a private sector approach like Medicare Advantage. And if you talk to folks who have Medicare Advantage plans, they are private insurance, but the satisfaction level is extremely high. I think a lot of people really like the Medicare Advantage program on both sides of the aisle. So we could see even within the public option it being manned by the private sector. We could also perhaps see lowering of Medicare age to 60. This would take legislative action. I don't know how likely it is. There are pluses and minuses to everything. I have heard that the unemployment rate among the 60-plus group is rising, so perhaps it does make sense to make Medicare available at a lower age. In terms of COVID-19 relief, as we know, Congress never passed any additional relief after the FFCRA and the CARES Act. There were a couple of bills that were introduced, one in the House and one in the Senate. There's the HEROES Act and the HEALS Act. Both of those measures ultimately stalled. The HEROES Act had that 9-month COBRA subsidy that I think would have been helpful to a lot of people out there, but it does not look like it will pass this year. Likewise, it doesn't really seem that there'll be any additional relief for FSAs, either dependent care or health FSAs, before the end of 2020. So we can take questions on forfeitures if there's any at the end of the presentation here. We know that health FSA election limit for next year remains at $2,750 for 2021. And so in light of the lack of congressional action on COVID, the president did issue a few executive orders over the last handful of months. The first one was a Fica Deferral program that allows employers to defer FICA taxes in the fourth quarter of 2020 and then pay them in the first quarter of 2021. Part of the promise was if the Trump administration won, that he would make these FICA deferrals permanent. But that would have taken legislative action, and even if he had won, it seems pretty unlikely that could have happened. And as a result, we have not seen too many employers attempt to take the government up on this option, especially since if an employee were to quit, the employer would be stuck on the hook repaying the employee's share of that deferred FICA. Another executive order dealt with prescription drug prices. It was commissioning a study to look to see what it would look like if drug companies had to sell certain high-cost prescription drugs to U.S. residents at the same price they sell to other developed countries. Interesting approach there. We'll see if the Biden administration adopts it as well. And then also there's an executive order on pre-existing condition exclusions, which I think was just kind of forecasting the administration's stance on protecting folks with pre-existing condition exclusions if the ACA were to be overturned. So whenever thinking about COVID-19 issues and leave issues in the FFCRA, you should also consider any state-related COVID-19 relief. There are about 8 states and a handful of cities that have passed some measure of COVID-19 related relief. A lot of times it builds on top of the FFCRA that fills in gaps there. So just be aware of that as well. We're seeing many more states implement these kinds of laws. Something else that I think employers and participants have been dealing with over the last handful of months is this national emergency and the extension of deadlines for things like notifying the plan of HIPAA special enrollment events and COBRA qualifying events and paying for COBRA. And there's all kinds of extensions that were effective beginning March 1st of 2020. And this period continues until 60 days after the end of the COVID-19 national emergency. And I think, many of us were hoping, expecting, praying that the emergency would end by now, or would have ended maybe a couple of months ago. But shortly, we'll be up on 1 year of this national emergency. And in fact, while the national emergency might continue into the foreseeable future, and depending on what happens with vaccines and so on, the federal agencies generally can't suspend a federal law for longer than a year. So even if the emergency extends beyond March 1st of 2021, the relief should expire, and then the notice and election periods should roar back to life on March 1st of 2021. We haven't seen any guidance on this yet from the Department of Labor, although The EBSA disaster relief notice from, I think it was in early April, it does reference, I think it's section 518 of ERISA that talks about this maximum 1 year delay. So hopefully we'll see a little more guidance on it as we get closer to March 1st, but I think there should be a kind of an end date of this outbreak period, regardless of what happens nationally, so that plans can, finish up their 2019 run-out period for their FSAs and other administrative functions. Okay, so the next two slides are on these price transparency rules from CMS. And this first one has been around for a little while now. It was actually released in November of 2019, and it is intended to go into effect 1/1 of 2021. It is actually still being litigated. Hospitals are suing over this rule, but it basically requires hospitals to publicize their standard charges for the items and services they cover, including the minimum and maximum negotiated charges, the cash price for at least 300 of what they call shoppable services. CMS will specify 70 of them that the hospital must disclose if they cover them, and the other 230 are chosen by the hospital. This rule also currently being litigated, although it is slated to take effect 1/1 of 21. So I'm not sure exactly what's going to happen there. And then more recently was a price transparency rule for plans, for health plans and insurers and TPAs that requires them to make personalized out-of-pocket cost information for all healthcare items and services that the plan covers and publish the in-network negotiated rates with the network providers. And so the way it would work under this rule, most self-insured plans and insurance carriers, except those that are grandfathered, would need to disclose this price and cost sharing information. So you would get, as a participant, if you were going in to get some services, you should receive a personalized out-of-pocket summary of that cost information. And then further, you would even have access to the historical allowed amounts for out-of-network providers, so you can really see what you're likely to get billed from that out-of-network provider. This rule will be phased in between 2022 and 2024. It is almost certainly going to be challenged in the courts. And the other thing that I thought was kind of funny is that this rule relies entirely on authority from the ACA. So, if the ACA were to be judicially repealed, so would the Trump administration's rule on price transparency. So before we wrap up here, I just want to spend a couple of minutes on ACA reporting, and then we'll open it up to questions. So quick update on ACA reporting. The IRS continues to enforce the pay-or-play employer mandate. They just recently started sending out letters for calendar year 2018 reporting. The letters that you get may take various form. It could be a letter 226J, and that is proposing a pay-or-play penalty. These ones are pretty easy to respond to as long as you do it timely. A lot of times it is simply a coding error and something that can be addressed pretty easily and fixed and get the penalty abated. A little more concerning is the letter 5699, and that one you may receive if you didn't do your reporting and the IRS thinks you were an ALE and you were subject to it. This one is pretty concerning if you get it and you didn't do your forms, but as long as you respond timely and send in the forms, you're not guaranteed to get a penalty letter on the back end. The 972CG letter is really concerning, and that is the IRS proposing a penalty because the employer has either filed late or failed to file electronically when required. These letters have a very tight time frame for a response. You must be timely, or you can jeopardize your ability to appeal. The penalties can be somewhere between $260 to $280 per form, depending on the calendar year being reported. So if you get a 972CG letter, don't sit on it. Advise notify your BCI consultant. They'll get in touch with us if you'd like to engage us, but we definitely recommend getting someone who's familiar with these letters to respond. They almost look like they're a scam because they're formatted so oddly, but they are legit, and thousands of employers around the country are getting them. So how has the IRS really done when it comes to enforcing and collecting penalties under the pay or play mandate? The TIGTA office, Treasury Inspector General for Tax Administration, looked at the IRS over 2015 and 2016 and looked at their the letters they sent out and saw that while the IRS had proposed penalties of nearly $17 billion over these 2 years, they only assessed $750 million in penalties. So much less than expected. Their long-term tax revenue, they thought they were going to take in $167 billion over 10 years. However, the revised estimate waters that down to about $8 billion, which really shouldn't be a surprise to many of us. I think we all know that when you have over 50 employees, you're generally going to offer health insurance. Just a note about the deadlines for this season's reporting. The 2020 forms will be due to employees by March 2nd of 2021. That's a 1-month extension there of the typical deadline. The IRS deadlines for sending the forms into the service, they have not been extended. They remain March 1st or March 31st if you're filing electronically. You can get an automatic extension, a 1-month extension to file if you file Form 8809 before the due date. Plans still have relief regarding the 1095Bs. You generally don't need to send the B forms to employees as long as you're posting a notice on your website explaining how to obtain them. This is primarily for insurance companies and for small self-insured plans that are not applicable large employers. If you're an applicable large employer, you have the C series forms, and those are required to be sent to employees still. The 2020 reporting is also going to be the last year that the IRS will extend transition relief for good faith errors. Not entirely sure what they mean by this. They may be less forgiving when it comes to accuracy-related errors, and at any rate, this good faith relief does not apply to timeliness failures. One thing that we recommend with regard to this reporting is do everything you can to get it filed on time. You really don't want to be dealing with the IRS having to explain your reasonable cause for not submitting the forms on time. You can get the penalties waived for timeliness failures, but there's no guarantee, and they are getting more rigid about these timeframes as the years go on. And then lastly, changes for this year's reporting. The planned start month on Form 1095C is now mandatory. The instructions remind employers that there is no particular code to use when an employee waives coverage. You either use an affordability safe harbor if one applies. Otherwise, you would leave line 16 blank, and that informs the IRS that you may have some penalty exposure that month if the employee were to receive a premium tax credit. There's also a safe harbor for de minimis errors on the Aca reporting forms. If you're off by less than $100 in any given cell, then you may have an avenue for avoiding having to reprint and resend and resubmit these forms. A number of changes were made to reflect the availability of individual coverage health reimbursement arrangements starting in 2020. New information will be included, like the employee's age and zip code, and a bunch of other codes that are specific to these ICHRAs. That brings me to the end of my prepared slides. Do we?
Stacy, I
Okay,
do
so
any
yep,
questions in the chat box?
sorry,
I do not see any questions in the chat box.
me either.
Okay. Well, thank you so much, Stacy. That was a wonderful call. We will send out a copy of this recording to everyone that registered for the call. This will also be available on our website. And if you have any questions on this, please feel free to reach out to me, and I can reach out to Stacy for any additional questions or clarifications. With that said, thank you so much, Stacy, and thank you everyone for calling in and participating in this great informative call.
Thanks, everybody. Have a great week. Take care.
Have a great week.